right. Good morning, everybody. I am obviously not Senator LaMancha. She will be here later, as Travis noted. My name is Nathan Vassar. I'm an attorney from Austin. We do regulatory water, wastewater work, and it's a pleasure to be here. I want to start out just by echoing the praise that I've heard from so many of you and so many others, including elected representatives. Praise for what the summit is doing. Senator or Representative Cuellar just said, this is a watershed moment, and that is so true. For policy issues on water rights, on wastewater, on flood planning, this is a unique moment in time, and it's a unique opportunity that you all know the Nueces River Authority and as spearheading this event, and so many others are involved in. So, and I want just to echo that. My talk today is going to be about water rights issues. Now, some of you are very well familiar with some water rights fights over time, and so I'm going to talk about some of the recent policy questions, some of the big fights that have happened up at the state agency, TCEQ, that deals with water rights, who gets which appropriations, and how it's allocated across the state. So I welcome questions. I won't promise to have answers on everything, but I'm looking forward to going through it. So we'll talk about some of the basics of water rights in Texas, and certainly here in the Nueces Basin, very dry basin, these are critical issues. And so we'll talk about what does it look like to obtain and use a water right in Texas. And again, we'll discuss some of the permitting developments that have happened, including some major fights. We talked about this, some of the watershed moments. You've got right now those who are looking to develop water resources, and there are those who are pushing back against that for reasons that we can discuss. But it's critically important for our state, of course, to continue doing what we have been doing for decades in the development of water resources. So here's our drought map. Now, this was taken, I had to turn in my slides a couple weeks ago, but this was taken 2 weeks thereabouts. But it seems like everywhere west of the Colorado, and I did look yesterday, it's about the same now as it was then, although this obviously doesn't account for the storms of this week. But everywhere west of the Colorado is still in pretty dire straits. And certainly look right here, some of the, it's not quite the maroon color, although, it's getting there. And then, of course, the north of the red in the panhandle there, it seems like it's always dry there in the Canadian and in that part of the state. And so this obviously gets updated every week, and it tells the story of the cycle of drought to potentially flooding and then drought again. It's just a matter of time. All right, TCEQ and water rights. Anyone ever heard the expression first in time is first in right, first in right is first in time? You want to have an old priority date, and so a lot of the most senior water rights in the state have priority dates that date back to the early 20th century, some even older than that. And so when you're in drought, this is more than just a snapshot of where we are in time on drought, but when you're in drought, there's something that's called a priority call. And this has happened over the course of history. It happened in 2011, which doesn't seem like that long ago, on the Brazos River, where basically if you're a senior water rights holder, you can put a call in to either the water master or to TCEQ in Austin and say, shut off the spigots, basically, of everyone who's junior. So the older rights get to divert their water. The more junior rights do not. That's the idea behind a priority call. And so what TCEQ or the water master would do in that circumstance is look at the diversion reaches and the diversion points that are tied to the priority dates that are more junior, and they can make a decision to temporarily cut off those junior folks. And so that's the underlying concept of first in right is first in time, because it does matter, and it matters greatly during drought conditions. And when we talk about how firm is water, water is considered firm when it's deemed available during a repeat of the historic drought of record. I don't know if this region, and some of y'all may know, I don't know if parts of the Nueces experienced a new drought of record during the 2011 to 2015 time period, but certainly some parts of the state did. You know, for a lot of the state, what TCEQ looks back to is the 1950s and the drought of the 1950s when so much of the state was under just dire drought. But in the last 15 years, you've seen more changes in that regard. All right. So, what does TCEQ do when they get a water rights application? All right. First of all, they got to make sure water's available. And it will surprise some to hear this, but determining whether, if you want an appropriation of water, it only has to be available 1 year out of 50. 1 year out of 50 in order for them to make the appropriation, in order for them to say that there's water available. So they run their WAMs as the water availability models. And some of these are getting updated. In fact, I think, and Julie and Sarah may talk about this in the next presentation, but there was a push to do updates to the water availability models during the last session, if I'm not mistaken, but there was no funding associated with it, right? So, as TCEQ, please update your availability models, but we're not going to pay for you to do it. And that happens, obviously. But the idea is over time, you want to make sure that these WAMs accurately reflect the water that's available in the basin, because otherwise there's a risk of overappropriation. There's a risk of not having enough water during times of drought. So TCEQ runs their machine, their WAM, and they determine if water that you're seeking is actually available. This is just a screenshot showing some of what TCEQ uses, and I know some of this is really in the weeds, and y'all came here for some of the water rights fights, but it's important to know here's how this plays out at the agency. They do go through a process. Now, TCEQ water rights applications, they take time. It's not overnight. It's you submit an application. I mean, I think some of the more complex ones, depending on if they're challenged and fought, it can take 10, 15 years. I mean, I think the Brazos River Authority's SysOps permit, I believe it was submitted in 2004 or thereabouts, didn't get an opinion and ultimate decision until, I want to say, around 2015, and then it was appealed and went through its whole process. So it takes a while. So TCEQ staff will look at your application, see if water's available, run it through their process. And it used to be, and this is where it really gets interesting, is this issue of notice. Notice goes out, and there's an opportunity to protest. And it used to be until about 10, 15 years ago that the notice on a water rights application would come out early. It would come out toward the beginning of your application process. Well, now it comes at the end. So you get all the way through a couple years of back and forth with TCEQ. You get a draft permit, and you think, all right, we're ready to have our right. We can divert from, and then it gets protested. And so that's the process that goes through some of these. Now, I will tell you, there are limited. It's different when you're protesting a water right than when you're protesting a wastewater permit. What do I mean? So, in order to be deemed an affected person, which is really just to say that you've got skin in the game, you've got a legal basis to be fighting this particular permit. In the water rights context, you've got to have another water right. The idea is if someone's diverting water and you're just you're a citizen downstream, you don't have a water right yourself, you're not going to have standing. But if you are an interadjacent water right holder, and by the way, there are 4 different categories of use. You have recreational use, industrial, you have mining, and of course municipal use. But if you've got another water right, you can protest. Contrast that versus a wastewater setting. In a wastewater setting, you can have landowner protestants. Typically, if there's a wastewater plant, TCEQ will give a 3-mile radius notice to anybody and everybody. So it's not uncommon, and we see these when you're fighting in a wastewater application context to try and get a TPDS permit. It's not uncommon to see a host of landowners who say, "Hey, we've got concerns about nuisance odors. We've got concerns about water quality," and so in those contexts, you're more likely to get a greater number of protestants who show up and have a chance to fight. There are also several different, on the wastewater context, I call it 4 bites of the apple. There are really 4 chances that protestants have to get involved and try and stop the permit. Whereas with the water rights setting, it's really just one, and maybe at the preliminary hearing if it goes that far, but it's a much more limited framework. I mentioned what are some common mistakes in water rights applications. I think it's often a misconception that, oh, my property or this property I'm acquiring, whether you're a public entity or a private citizen, is next to a water course, therefore I have riparian rights. Used to be that way, but in Texas, all water rights except for domestic and livestock ponds have to have some sort of a permit. And so you don't have some automatic right just because you were near a water course. Some states still have that, but Texas went through a process in the 60s through the 80s in order to adjudicate all those claims, including riparian claims to water. Jumping into some of the recent fights. So we were involved on some of these, not on all of them. This is one that has taken up quite a bit of time for the last 2 years, but way up on the Red River, City of Wichita Falls are a client of the firms, and we were happy to help them with this. They wanted to build a new reservoir. This is the, so there's Oklahoma. I've seen 1 or 2 Sooners in here. I think Kennan's the Sooner, and we love them all the same. But no, there's a red, and then this is the little Wichita River that flows into the Red River. So you've got this is a reservoir system where you've got Lake Arrowhead, and then you've also got Lake Kickapoo on Little Wichita that feeds in to the Red River. And what was proposed is this new reservoir that could catch flows that can't be caught through Arrowhead or Kickapoo, and it would impound just shy of, I think, 300,000 acre feet there just upstream before the confluence with the Red River. We talked about how long some of these cases can go. Now, this was submitted in 2019, and then we had last August, we had a almost 2-week contested case hearing, which is just the administrative term for trial, but on TCEQ fights. And let me tell you, August is a great time to be in hearing because you're in the air condition, you're working long days, it's 100 degrees outside. But we were in the trenches for 2 weeks last August. What were some of the issues? So there have only been, and some of y'all can correct me if I'm misstating this, but in the last 10, 15 years, there have been, I can count 5 new reservoirs actually permitted at TCEQ. You've got Lake Ralph Hall, you've got Lower Bodark, you also have, I think, Lake Arbuckle that LCRA constructed. Just this past spring, City of Lubbock got Lake 7 permitted at TCEQ, and then you've got Lake Ringgold. So one of the key issues in this case was there were a lot of landowner protestants, and it's okay as a Texan to appreciate private property rights and also appreciate the development of water supplies, but there were landowner protestants who are in the footprint of the new Lake Ringgold, and they raised several issues. And this, some of the issues that were at stake were: is this too much water? So a diversion of 65,000 acre feet per year is what the water right seeks. But is it too much water? And is there a need, a quote unquote need for this amount of water? And the administrative law judge, so after this August hearing last year, you can see on the time frame there was a proposed decision that came out right before Christmas, and the judge said, "Great, you've met your burden of proof on 80%, 90% of the issues, but on three you didn't." It's quite the coal in our stocking right before Christmas. But the recommendation that the administrative law judge gave initially was to deny the permit on three issues, and we'll talk about them. One is this need issue. Do you need this much water? Two was on, you have to evaluate habitats. Like, what are the impacts going to be to wildlife and aquatic species? The third issue was more technical and in the weeds, and was whether you could use a full amount, 65,000 acre feet, for all those different types of uses that we had listed. The city didn't break it up and say, we want to use 30,000 for municipal, 20,000 for industrial, because you're not required to. But so on those three issues, the judge found that there was some daylight, in his opinion, between what the TCEQ rules require and what the water rights application provided. We contended that that was not the case. Thankfully, for the applicant and for water supply in Texas, just a few weeks ago at TCEQ Commissioner's agenda, the TCEQ Commissioners denied the recommendation from the judge, and they issued the permit. And they said, look, whether this wasn't in the opinion, but the idea was, you're always going to be planning conservatively for water supplies in Texas. That's the prudent thing to do. So some notion of, I called it the Goldilocks rule, some notion that you have to have a contract for every acre foot of water before you can get that appropriated, it's just completely out of line with, again, what Texas water supply planning has done over and over throughout the years. The commissioners also said there's not a standalone need requirement. You don't have to demonstrate, again, that there's some obligation to use all of the water in any particular year. In fact, we said that would be waste if you're going to be required to use it or lose it, so to speak. So we think the commissioners got that right. There was also an issue about, what does TCEQ do versus the Water Development Board? And so what one of the requirements of the rules is to look and see if a water right application is consistent with a need that's already in the state water plan. And we said, yeah, just look at the regional water plan. How many of y'all are involved with region water planning, whether here in the, you see a few hands here. Yeah, it's a critically important role. Every 5 years, you're putting out a plan that identifies what these needs are. Y'all know what it is. And so TCEQ's position was, yes, we of course look to our sister agency, the Water Development Board, and see what they recommend. The judge said, no, you have to do an independent analysis of need that's separate from what the Water Development Board does. Again, thankfully, the TCEQ commissioners said, no, we're going to stay in our lane. We're going to follow what we're required to do under our rules, and we will look and give deference to what the Water Development Board recommends. And sure enough, Lake Ringgold was and remains one of the key strategies in that case, Region B, in the Region B plan, and it's been in the state water plan. Another issue, habitat evaluation. So you get a water rights permit, that's only part of, for building a reservoir, that's only part of the challenge. You also have to get a Corps of Engineers 404 permit. Different agency, different level of government entirely. When you go through that process, you're going to do a full habitat assessment. You're going to look and see what is going to be the impact. Where do I have to mitigate in order to provide for additional habitat? That's part of that process, not that full process at the state level. And so what, thankfully, the commissioners determined is that all TCEQ needs to see is a conceptual plan for how you're going to address impacts to the environment, impacts to habitats. And again, that was something that was hotly contested. So we had the commissioner's decision back in mid-May, and it was in support of approving. It may, in fact, we fully expect it will be appealed by the protestants, and so that process itself can take some time. In fact, basically and some of y'all know this, but when an agency decision is appealed, you have to first finish up at the agency, in this case TCEQ, and finish challenging, checking the boxes, challenging it there, and then it goes to the court system, and then there are 3 different levels there. It's not on the slides, but there's a case on the wastewater side, Dripping Springs versus Save Our Springs Alliance and TCEQ, that's going all the way to the Texas Supreme Court. So you have TCEQ, then it goes to the trial court, Austin District Court in Travis County, then to an appellate court, and then to the Texas Supreme Court if it's appealed that far. So some of these decisions can take years before they're ultimately finalized. We'll see what happens in this Lake Ringgold case and how far it's appealed. But some pretty core fundamental policy issues at stake for this application, and really of broader statewide importance, including, again, supporting the intentionally conservative water supply planning, because you don't know when the next drought is going to hit, and you don't know if it's going to be more intense than the last one, and so it's just prudent to plan for that. Okay, just up 37 here, San Antonio water system. Some of y'all probably were following the SAWS application for their reuse. In fact, it was 2 weeks after our Lake Ringgold agenda. The SAWS case came before the TCEQ commissioners. So on this one, SAWS was looking to appropriate return flows. Now, I think most of this group is familiar with return flows, but your wastewater effluent is often the lowest hanging fruit of any water right you can get. It's already there. It's in stream. We like to say it's always raining at the wastewater treatment plant. You can expect that reliability. Well, not all of it's appropriated. In fact, under the BRA, I mentioned the SysOps case a little bit ago. I'd say the discharger has dibs, so to speak. The wastewater discharger has an ability to appropriate their own return flows if they do so, if they choose to do so. But it can be others can claim it otherwise. So in this case, SAWS said, we would like to appropriate, we want to get a permit for our wastewater discharges. So they went through the whole application process. We talked about it at the beginning. They went through, and it was protested by a couple entities, and one of them was GBRA. And so in this case, GBRA was stating that, well, we GBRA have been reliant upon those discharges, and those effluent discharges were really the basis for some GBRA water rights. And we're not involved on this particular case, but we've been watching it from the sidelines. What the commissioners ultimately did on that case, in fact, the administrative law judge found, and they were going back to the 1950s. They were looking at decisions from TCEQ's predecessor agencies going all the way back, just to see, hey, when the base water right for GBRA was issued, did TCEQ in fact issue that based on the availability of SAWS return flows? Which they can do that. They can run their water availability models and say, you know what, we're going to give you this water right, but it's only because of someone else's discharge. So that was the big tug of war that was in place. And in that case, the SOA judge, the initial judge before it goes to TCEQ, had recommended it said issue the permit, but put some special conditions on the permit to protect other water rights who may have been reliant upon, whose water rights may have been reliant on these SAWS return flows. The commissioners ultimately stripped out those particular provisions in the PFD. And they ultimately issued the permit, again, about 2 weeks ago. We'll see if that one is appealed as well, but major policy implications for reuse. And so, as I mentioned, reuse permitting, when I know many of y'all involved in the water planning process, reuse permitting is, it's there. it can be a key part of any water supply portfolio. And as far as cost goes, depending on diversion points, it can be among the cheaper. None of it's cheap, but among the cheaper alternatives that you're looking at. So saws will likely get appealed as well at some point, but we'll see what ends up happening on that one. There are some others here that are listed, and I'm not going to go through each of these. Some of these are within the Nueces River Basin. These just give a snapshot of what you can do in a water rights application. Sometimes you're looking, if you've got an irrigation right, you have to identify for TCEQ what acreage you're going to be using that water for. And so in this first case, you see an example of that. You see changes to a diversion point, which, by the way, you think, all right, if I'm just moving my take point from downstream to upstream, that should be a pretty simple amendment, right? Well, if there's somebody else in between your current diversion point and the proposed diversion point, they can protest. And, because again, the idea is, are you going to be interrupting their water supply as well? This third one here is just talking about accounting plans. Every year you're supposed to, if you've got a water right, you're supposed to send TCEQ a report of how much water you used in the prior year. And so not all water rights require a complex accounting plan, but some do. And you're supposed to, again, identify what you're using. Now, this came up last year during the sunset process at TCEQ, and I know Julie and Sarah will talk a little bit about sunset, but there was a question about should TCEQ commence cancellation of water rights for non-use. You talk about something that gets people fired up. This notion of canceling a water right that's held by somebody, and TCEQ really hasn't done that for decades, but I believe it was one of the initial recommendations to recommence cancellation of water rights. Again, the idea being, well, someone's not using their water right, surely someone else could put that water to use. That was ultimately not recommended in the final. It was not included in the final sunset package that went through, but it's something that's there. So we mentioned earlier on the slide about just applications and common mistakes. Accounting plan mistakes are commonly the seen in your review of water rights. And so when you've got an accounting plan that's dated, when you've got an accounting plan that doesn't fully account for other diversions in stream, that can impact the availability of water, and it can impact. It can be a common a point for protestants to push back against. I did mention, and it's worth, we have a few more minutes before questions, it's worth talking about is this Dripping Springs case. And again, this all happened since I submitted my slides a couple weeks ago. But if I may shift from water rights to water quality for a moment, and I don't see anyone objecting right now, but it's okay. You can object quietly if you need to. But there historically have been zero discharges in the Highland Lakes. It goes back to legislation even in the 1930s, 1940s, thereabouts. And the idea is the Highland Lakes wouldn't get wastewater discharges. You'd have to dispose of wastewater through land disposal, and you get your TLAP permits. Well, certainly, throughout the region, that's been the expected practice and policy. We're not involved directly in this one, but we have been involved through different industry groups on the issues. City of Dripping Springs applied for a discharge permit to discharge into Onion Creek. So they have the ability, and I think the quantity of flow was significant. And TCEQ said, yes, you've met the requirements. Here's your permit. We talked about the administrative appeal process. Well, that happened. It was appealed to Travis County District Court. And what's supposed to happen under, again, the standard of review is that the agency gets deference. The agency is supposed to get deference because courts typically say, we're not going to substitute our judgment for that of the experts who are doing water rights, TPDS permits. And so it's called a substantial evidence review at at an administrative appeal. Well, the Travis County District Court looked at the Dripping Springs discharge, and they said, you know what? We don't like that. I believe it's total phosphorus. We don't like the nutrient loading that's going into Onion Creek under this permit. It's something like 10x the existing nutrients that were found in the stream, and said basically TCEQ is turning the Clean Water Act upside down. That was from the opinion. They said the Clean Water Act's being turned upside down, and so the applicant, Dripping Springs, then had to appeal that decision to the next level. It actually went out to the El Paso Court of Appeals just for docket load management, and the El Paso court said, no, you really did meet your requirements under the discharge permit. We think TCEQ was right in issuing it. So then that got appealed. And it was unclear until last week whether the Texas Supreme Court would take it up, whether this discharge permit should be issued. And yeah, last Friday, the Supreme Court said we're going to take up the Dripping Springs case. And so that'll be something in the coming months to be watching. A lot of us water and wastewater nerds really get excited when the courts, and sometimes very worried when the courts take up these important cases. But, basically, a question about how much nutrient loadings are too much. There's a lot of concern on both sides, both the discharger side of things, and not everyone gets along, and that's okay. But, there's a sense of we have to dispose of, and we want for reuse purposes to use this effluent, to use these return flows. You have those who say, well, significant nutrients are impactful to the environment, and they're saying that there should be tighter controls. And so there's going to be a lot of interest following what happens there. There was another case related to this, City of Liberty Hill, came out a couple months ago, I think back in March or thereabouts, where Liberty Hill had a similar, I think they had a total phosphorus limit. It was recommended initially to be, I think, 0.15. It was 0.15 was the recommendation, milligrams per liter. The judge said, no, we should make that more stringent and make it 0.015, which is basically a lab non-detect. And then the commissioner said, yeah, let's meet somewhere in the middle. Let's do 0.02. So there's a lot of numbers, but basically not Dripping Springs, Liberty Hill in this case said, well, we can't even treat to that level. And so, I don't know how we can accept this permit. So Liberty Hill has filed a motion for rehearing. That's going through its process at TCEQ. We should know more in the coming months, but I expect that one's going to be fought over as well. So those are some of the, I get excited about these things. I know it's a little bit of a report from the inside of administrative decisions on water rights and water quality issues. But as I said at the outset, there are key issues at play for your communities, for your water rights, and for your discharge permits that are at stake. And so there are several ways to be involved. I strongly encourage taking time to participate in. TCEQ has several advisory work groups. They have one on water quality. They have one on water rights and water supply. They also have one on drinking water. I'm happy to point folks in that direction. And but remaining engaged, coming to things like this, and making sure that you're watching what is this decision, what impacts does it have on my water right, on my water quality. So with that, I appreciate the time to get up here and visit about these cases, and certainly if there are any questions, I'm happy to take them.
All right, so far I have one question from the audience. To clarify, TCEQ can override a judge's decision in a water rights case?
That's a great question. Short answer is yes. So a lot of people, when you think about trial, you think about what you see on TV and you're in a courtroom. When a permit is challenged, when a TCEQ permit is challenged, the TCEQ agency actually ships off that challenge to the State Office of Administrative Hearings, otherwise known as SOA. And so there's an entire agency that exists to adjudicate different administrative claims. So the SOA judge, he or she has authority to make a recommendation, back to TCEQ. It's called a proposal for decision, or PFD. And so the judge's decision is what, again, he or she determines is the right decision after going through a trial and taking all the evidence. But ultimately, the decision makers are the commissioners at TCEQ, and they have the discretion to approve that proposed decision entirely. They have the discretion to deny it. They could also pick and choose. But that's a great question, and that's what happened in both the Saws case and in the Lake Ringgold case. Was that there was a decision to say thank you very much for your thoughts. We disagree for these reasons, and we're going to issue the permit. That's a great question and key to the procedure. Yeah.
Are there any other questions from the audience? Full disclosure, Nathan is our attorney, so on our dime, do you want to ask a question? No, just kidding.
Hi, Nathan. One of the interesting things I think this audience needs to know about is the issue of pristine streams in the upper reaches of the Nueces Basin. The only way those are going to be protected is to keep phosphorus and nitrogen essentially from entering those streams. That's the case of Liberty Hill. Liberty Hill put in a domestic sewage plant, and for 1.5 miles below or more, depending on the weather, below Liberty Hill's plant, the stream color you have up there is light as to the amount of algae for 1.5 miles. People can't even let their dogs go to the water. Liberty Hill has insisted that they have the right to do that because, in this appeal, because that's the way the condition of the river is, because they started it. There are plenty of reasons and plenty of alternatives where we have pristine streams to make the effort and to consider the costs to remove the phosphorus and algae. Same situation were to happen at Dripping Springs if they get theirs. So this is not necessarily quite as much of a legal issue as it is the fact that technology moves, people don't.
Yep.
And so I'd like your response.
I appreciate that, Kenan, and to be clear, you're exactly right. The science behind this is absolutely key. And there are questions. In fact, I was on a call earlier this morning where we're debating, okay, how do we engage with TCEQ on what the right science is as it relates to nutrient limits? And so, it's a combination of both the legal challenge of what can TCEQ do, but also, again, what's the natural environment and what are the impacts of those loadings on the stream. And again, there are people in this room who will disagree strongly on different pieces of that. And I'm not taking a particular position on it right here. But I know, there's the water quality of our state has to be maintained. And some dischargers have done a better job than others historically of being good stewards of that resource. And so you're absolutely right. The science plays into it. TCEQ is supposed to be, when they're looking at water quality standards that are put into place that then drive the permit conditions, that is part of that analysis. So Ken, and I appreciate that perspective, and sorry for calling you out as a sooner or earlier, but no, we appreciate that angle.
Yes, Nathan, how do we get better dissemination of information when there is interlocal agreements when it comes to the water rights? For a case in point, in 2019, Formosa, who had an agreement with the city of Corpus Christi, under their agreement, they had to notify the city of Corpus Christi 1 year in advance if they ever decided to utilize the 25,000 acre feet of water that Corpus was enjoying because of Formosa's willingness to provide that. So in 2019, city of Corpus Christi, and I think it was in November of 2019, got a letter saying, we're putting you on notice. Come 2020, you're no longer going to be able to utilize our 25,000 acre feet of water. I doubt it very seriously that anybody in this room has even heard about that agreement. But there needs to be a clearinghouse. I don't know if it's got to go back to the Water Development Board or whoever, because and the only reason I even knew about it, it was referenced in an ed op piece that was done by the mayor, Joe McComb, and it was just a little tiny reference, and it caught my attention. So I called him, and he explained it to me, and told me that this is what had taken place. But so here we are, 2024, 25,000 acre feet of water gone since 2020, and we've done nothing, in my opinion, to replace 25,000 acre feet of water that we need badly. But forget about the 25,000 acre feet. And this is where I think we need to have more information in terms of the real picture of what are we really facing by the year 2030, 2035, unless we start doing something about diversifying our water resources. Because without that, I don't care, and you pointed out junior rights, senior rights, it doesn't mean nothing. Because if we're all drinking out of the same water, and if there's no water up in the lower Colorado, I don't care what senior rights you got. If there's no water, there's no water. And so, that's the kind of information that I think that we all need to try to get our hands around, and maybe we can all start reaching a consensus and starting to diversify our water needs. Because until we do that, and we're all drinking out of the same glass, and it's not going to work. And we have the highest water rates in Corpus Christi of any city in the country. It's the only city that I'm aware of that when you use less water, you pay more for it. Go figure. And the reason is because of their budget. They're used to having a revenue source based on the water usage. So when that's declined, what do? They increase our rates. And so, but I think there needs to be a better dissemination of information as it applies to water right, not only down here, but all across the state, so that because look, elected officials come and go, but I think there needs to be a continued dissemination of that information so that everybody's on the same page and understands what the task is ahead of them.
That's a great point. And, I don't have a lot to say in response other than, the regional plans have a piece of it, but not, everything like you're talking about on notices and, when water will all of a sudden come offline. Certainly that might be of help. There's not, at least to my knowledge, some existing clearinghouse for that information right now. And so it's, maybe through things like this, we can get stakeholders involved and find a way, because these are critical things. So I appreciate the thoughts there.
Good morning. I just was going to pick up on a line that you said early in your presentation and wondered maybe if you could give some guidance, because this morning we're going to transition here to legislative update. We've got a legislative session. Most of us that work in the water rights arena, no matter which, if you're a government official or if you're just an advocate, worry that so much of the water code is old. It's got, it hasn't been revised in particular arenas in over 30 years. You said something to the effect that, we need to do modernization or updates because, well, technology has, modernized. Who do you think, which organizations, alliances, do you think we could go to help us, or who's working on it, I guess, because we need to have revisions so that when we go to TCEQ, we're not looking at, law that really just isn't right for us. Or I don't know what your thoughts are. For me, it's not right.
Certainly a lot of the, a lot of the statutes, to your point, haven't been updated in many years. And I think, I'm not going to hit on all of them, but, several industry groups that I'm personally involved in. In fact, we'll have WHEAT and TWCA right after this, are two of them that are key. And again, I'm not going to try and name everything, but they are active. And I think Julie and Sarah can certainly speak to some of the things that they're doing. We ask ourselves, where are the initiatives that are needed? and it's a tall hill, to climb when you're talking about legislative change. And so, getting part of the key effort is getting stakeholders who understand these issues, who understand why there's a need for a push for something, and then are showing up to testify and are in the ears of the decision makers in Austin. But it's a great point, and I'd certainly recommend getting involved with the couple groups that are about to speak here and remaining engaged in that setting. And asking, you can ask State Senator later this morning, and I know we appreciate her making the trip. So thank you very much.
All right, thank you very much, Nathan. I don't want to get into a second billing hour here.